Welcome back to I Now Pronounce You Divorce, a podcast by Melone Hatley, PC, where each week we have real conversations about divorce, custody, family law, estate planning, and the major life transitions that come with that. My name is Erik McCauley. I'm the managing attorney for Melone Hatley's Virginia offices. Today, we are joined by Kate Philleo, a financial advisor from the Waterfront Advisor Group of Raymond James. Kate, please introduce yourself and tell our audience a little bit more about what you do and how you help people.
Hi, I'm Kate Philleo. I am one of 4 advisors with Waterfront Advisory Group of Raymond James. My team specializes in holistic financial planning for individuals, families, and business owners. We put together personalized financial plans to focus on their long-term goals.
Well, we got a few topics we're going to cover today. And the first one is why estate planning isn't just for quote unquote later in life. So what are some of the biggest misconceptions people have about estate planning?
So I think one of the biggest misconceptions that people have about estate planning is that they think that they have more time than they may have.
Mhm.
A lot of the time, there are accidents that happen. I mean, that is kind of one of the key times when having an estate plan or some type of will is beneficial for the family to get some clarity on what their intent is.
Mhm.
So, in a perfect world, you do have 20, 30 years, but you never know what's going to happen. And having just that outline of what your family can expect and how they can move forward is really, really key.
Yeah, and that's something that a lot of people don't think about is the unexpected. What can happen? I'm healthy, but then you get in car accidents. I read a statistic recently that somewhere around 70,000 people a year, pedestrians, get hit by cars. That's not even including just regular car accidents. So, and that's a very good point. Jeff, did you have a comment?
No, I agree. I think the time is now. Anybody over the age of 18 should start seriously looking at estate planning.
For both of you, have either of you ever had a client just come on and say, my family will be able to work everything out without any problems whatsoever. We all get along just fine.
Absolutely.
Yeah?
Yeah.
How's that work out?
Money brings out the best and the worst in folks. So you never really know what you can expect. And you don't know if your family will actually be able to work together on those things, or you may have some family members that feel more entitled than others to a portion of whatever assets you've had.
So why should someone start thinking about this earlier than they typically do? Kind of ties into what we've already talked about a little bit.
So estate planning should take time. You should be coordinating with not only your financial advisor, your estate planning attorney. You should be talking with your doctor, your tax professional. You should be talking to any relevant parties that the plan touches so that they kind of have some understanding of what to expect when that estate plan goes into whatever role you have into your life. The other aspect would be if you are a high net worth client or an ultra high net worth client, a lot of the time the estate plan takes place during your life. So you'll have annual gifting or lifetime gifting that starts while that client is still alive.
Mhm. Well, this kind of ties to the next question. What risks do people take when they put in a claim in place? And at least, personally for me, my father-in-law, years have already passed away. He got a diagnosis of dementia, but beforehand, I had drafted a power of attorney for him, like literally just in time. He was still coherent, he was still lucid. But my wife being able to have that power of attorney meant that she was able to take her to his doctor's appointments, the HIPAA disclosures, get access to all those records without having to get a guardianship, conservatorship, without there being court oversight, attorney's fees, all that sort of thing. And you never know when somebody's going to get sick. Maybe one day they're lucid and the next day they may not be. So aside from that, what other risks do you typically see when people delay getting a plan in place?
So if you don't have some type of estate plan in place, like a will or trust, you risk your entire estate going to probate, and that can be a long, drawn out process. It can be expensive. You also have family conflicts, people arguing, whether that be just within the family or in court, which could exacerbate those costs as well.
Mm.
You really kind of leave it up to someone else to decide what to do with your assets. So whether that be the state or if your family can decide and kind of figure out what to do with those assets, there should be more clarity. You should leave some type of plan for for your loved ones, especially in a time of high emotional distress when people are going through like the mourning process, and there's other human aspects of losing a person that they should be focusing on.
Yeah.
Now, not every state has an estate tax. There is a federal estate tax, which I believe is currently 13.6 million, Jeff. Is that
I think it's 15 now.
15 now? Okay. Somewhere around that. I know Virginia doesn't have one.
Right.
But what other kinds of, at least, in your experience being a Virginia licensed attorney, what other kind of taxes and fees are associated with probate that somebody might have to pay?
There would be an estate tax that's basically assessed as part of the value, a percentage of the value of the property that's going to go through probate. I say it's more of a fee to the court to cover the cost of going through the probate process, and it pays for court processes and things like that.
And if you pass without a will, it's called passing intestate. And I believe in Virginia, if you don't have any children, then does it go to your parents or your siblings first?
They're going to go up.
Yeah.
And then they're going to go down. They're going to go up, over, and down.
Up, over, and down. It's a good one.
It's a very complicated thing. It's the 6 degrees of consanguinity. And we learned that in law school. But basically, if someone passes away and they don't have any heirs that they can give, the state can get their money to, it's going to go up to the parents. If the parents are alive, they go to them, and then it's going to go over and down to brothers and sisters and things of that nature.
So, Kate, how would you explain the value of planning to someone who thinks that they, quote unquote, don't have enough to justify?
So that would be kind of a mindset shift. It doesn't need to necessarily be what you have. It would be more so how you want what you have to be distributed, what you want to do with those assets, how you want them distributed, and what timeline you want them distributed in. So it's more so about control over your own assets rather than having someone else decide for you.
Mhm. And for most people, their most valuable asset is their house. So even if that's the only thing that you have, if you have multiple children, so you have 5 kids, and I've worked across a few cases like this before, if you don't have a will, then the house is going to go to all 5 of those children in equal parts. And if all 5 of those kids can't agree on how they're going to divide the house, then you're facing possibly a partition lawsuit, having to deal with that through probate, and then just gets messy. And that house could end up, instead of its same family, it could end up with somebody else. So that's a good point. So for the second topic, building a strong foundation, Kate, what are the core elements every estate plan should include?
Yeah, so there's 5 essential documents that you should have. So the first would be a will. And that's going to be kind of the outline of how you want your assets to be dealt with. That would name a guardian if you have children. You would have a living will. So the living will is more so about end of life care, and um, if you want sustainable care near that time, you would have a living trust and a living or any type of trust. I mean, there's so many different types of trusts. So a living trust, I think, is the most common. So it would be either revocable or irrevocable. You could have a marital trust. You could have a generation skipping trust. You could have a life insurance trust for more cash flow. If all your assets are tied up in liquid investments like a business or like real estate.
Mm,
There's so many different types of trusts that you have, and that's kind of more of a conversation to have with your estate planning attorney. You would have uh, your durable power of financial affairs.
mhm.
So, yep, power of attorney. And that would just be about any financial aspects that you have. So, any bills that you do pay, make sure that there is financial continuity, even if you are unable to make those decisions. And then you have durable power of attorney for your medical decisions. So, those are kind of the 5 key essential legal documents that you should have that any estate plan would have.
Mm.
And we try to get our clients to kind of think about what they want their estate plan to, how they want it to function. So is it going to be for distributing, or is it a fortress? Are you trying to protect assets? Or are you trying to disperse assets? What is the intent, so that you can kind of have that conversation with your other professionals?
We
Now, you mentioned two different types of powers of attorney. So, Jeff, could you provide some insight as to why it might be important to separate powers of attorney for financial affairs versus medical decisions?
Right. You have a medical power of attorney, and you can also have a general power of attorney. Power of attorney, I like to say to people, the regular power of attorney is just for your life management type things, going to the bank, making financial decisions, getting the mail from the post office, things like that. Life management, the logistics of everyday living. And it can include things like taking care of pets is one. The other type of power of attorney is medical power of attorney, and that deals specifically with wishes and things that you want to have done to you or done for you or done at your behalf for medical, all the medical stuff. It's goes from everything from putting you into a long-term care facility, maybe having someone come into your house and take care of you 24 hours a day, 7 days a week. All these things take a lot of coordination between an estate planning attorney that's designing these documents. And then if someone's going to actually make this work in practice, the financial planner needs to be involved to make sure they've got enough money to say, okay, I want to have somebody in here 24 hours a day, 7 days a week, or I want to live in a nursing home for the latter years of my life. A really well-run nursing home in the Hampton Roads area for extended care, for memory care and things like that can be $10,000 a month. So it's very important to just not put the document in place, but to also have resources in place to pay for it. And I think that's where the financial planners really come in.
Yeah. Working with CFPs, CPAs, all the acronyms. Kate had also mentioned trusts.
Yep.
So, in your experience, who would be a good candidate for a revocable living trust?
A good candidate for a trust would be someone that has possibly some businesses, business concerns that they have to worry about, some LLCs under their names, some corporations that they're a part of. You could also put assets like your house into a trust, rental properties, different things like that. Um, Anybody with assets that they want to protect is a good candidate for a trust. There are very many kinds of trusts, and they all have different functions that they'll perform.
Yeah.
So I like to tell people it's great. They call up and they say, I really want to have a trust. Why? What do you want a trust for? What assets do you have? What are you trying to do with them? When are you trying to do it? Now or after you pass away? And then what is the point of the trust? Because it's easy for people to say, I want to have a trust, and they think that they've done something meaningful, but then they don't fund it. They don't put their house in the trust. They don't have any assets in the trust. So you hear about people all the time. I want to have a trust. It's going to pay my grandchildren money for this or that for 100 years from now. A trust fund, and that's the ideal candidate for a trust, right? But they come in there and they say, well, I'm going to put my house in the trust and I'm going to have payments going out to my grandchildren for 100 years. Well, the only asset in the trust is the house. So you have to figure out in your head, before you put a trust in place, what is the goal of this trust? What do I want to have in it? What am I trying to do with it? Who am I trying to help with it? What am I trying to protect with it? And go from there.
Yeah. You kind of pointed out something there. One of the main advantages of a trust is that it avoids probate, but then either people don't pay attention to their attorney's advice, or their attorney didn't actually advise them correctly about funding the trust,
Right.
or they might sell that house, buy a new house in their own name, not put it back in the trust, that sort of thing. And then the trust is pointless. So no, it's a good point.
And they may have other assets, quite frankly, that are outside of the trust that they still have to go through probate for. So it's important to update it too when you need it. I like to say, what happens if you win the lottery 5 years from now? You need to figure out what you're going to do with that money, because it's not automatically going to be covered. May not automatically be covered by a trust.
And then definitely lab of federal state.
And you want to talk to your financial planner too, because you have all kinds of financial things to worry about as well. So
yeah. All right. So for the next topic, aligning your financial strategy with your estate planning. Kate, how should someone align their financial accounts with their overall estate?
Yeah, so I think it's really important. I mean, you guys kind of touched on it, to fund the trust. So you want accounts to be named properly. You want accounts to be created in the way that you intended them to be, whether that be an individual with a transfer on death designation, or if it's a joint, if it's joint with rights of survivorship. It's really important to make sure that, first of all, it aligns with what your intent for the estate plan is. And then do your listed beneficiaries align with that as well? Because if you have a TOD agreement on those accounts, it's going to be an automatic transfer of wealth. So if that doesn't align with what you've had intended with the estate plan, then you've got misalignment, and that could be a big issue. So we always try to get our clients to not only have TODs on the account, so it's that immediate transfer, but if the intent is to put that money or those assets into the trust, maybe you have the trust listed as the beneficiary for that account. Just really depends on what your intent is.
Yeah. And one thing that ties into that is beneficiary designations. And that ties into what Malone Hatley also does, divorce. At least, in the jurisdictions that I practice at, there's been case law about, if you have a settlement agreement in your divorce that says that your ex is supposed to get this life insurance payout or this retirement account payout, that sort of thing, and you don't update it, or your ex-spouse is not supposed to get it and you still don't update it, and then you remarry and your new spouse doesn't get that because you forgot to update your beneficiary designations. That became such a problem that in Virginia, they passed a law over a decade ago that required every final decree of divorce to have in big bold letters a paragraph that explained this, that a divorce does not automatically change your beneficiary designations for life insurance, retirement accounts, and things like that, because it was such a problem. So that's why they would come talk to you about these kinds of things.
I can imagine it's going to be a lot of legal things as well, which is not my forte. But yeah, I would definitely have them talk to their attorneys and their lawyers, because I try not to get in the middle of things. If you could show me the document and that's what it says, then we follow what is written in the legal document.
What are some examples where coordination between an attorney and an advisor made a big difference for you?
So I think coordination between all of your professionals need to you all need to have conversations as far as like the intent of what the client wants,
Mhm.
and make sure that everything aligns well. We already kind of touched on titling things properly. If you guys have a trust that is written a certain way, there's like a date in the title, then that date needs to be in the title. If it's not titled properly, then the document is going to uphold and you're not going to have it funded. There should be a conversation between all of your professionals to make sure that everything is written properly. There's no misalignments. If you pass and one of your accounts is titled improperly, then it could go to probate. It could completely bypass the tax strategy that you've laid out for it. It really depends on what the situation is and what
Yeah.
it kind of got skipped. So having all eyes on it is always beneficial,
Well, in your experience, how often should somebody have their financial and estate plan reviewed?
at least annually. So it's going to be a living, breathing document, just like your financial plan. You should be reviewing it at least annually, unless you have some type of big life event. And that could be marriage, divorce, birth, death. That could be a job change.
All right. So regarding protecting your children and loved ones when it comes to an estate plan, what should parents consider when planning for minor children?
Name a guardian.
Mhm.
Yeah, that's a big thing, right? People think that their families are just going to figure it out and they don't name a guardian. That's not always the case. And then you have the state deciding who is going to take care of your kids. That guardian should be capable, not only on like a values side. You should absolutely share values with that guardian so that you know that your kids are being taught the values that you want instilled in them, but also on a financial aspect. And you really need to make sure that that person is fully aware and taking on that responsibility.
As well as designating somebody who controls the financial assets. Like if you have a trust set up, who's the person who's going to be providing for your children with the money that you earned?
Yeah, absolutely. And I fully believe that those two roles should be different people. You
Yeah.
should have some type of checks and balances set in place to make sure that you have somebody who is taking care of your kids. And then on the finance side, so things don't get intermingled.
So how can a trust, and this is more for you, Jeff, how can a trust ensure the assets are used the way that they're supposed to be.
Well, the trust itself, you need documentation for the trust. And that's what I was talking about earlier. What is the trust going to be for? What is the point of the trust? And the person that designs the trust, makes the trust, and creates the trust can put in there language that says in clear terms, this is the point of this trust. This is what this trust is for. This is how it's going to be used. This is who's going to benefit from it. This is who's not going to benefit from it. And these are the things that we want this money to be used for. This is how we want it to be distributed. I'm not just talking about what year the person gets the money. It could be 18, 21, 25, whatever the age may be, but there can be restrictions. You have to have a clean driving record if they're going to buy you a car, or there's other things that you could put in there. You have to be gainfully employed to be able to do these things. I think these things are still legally enforceable with a trust, so.
So how can financial structures help provide stability and guidance for younger beneficiaries?
I think one of the key aspects of kind of laying down the groundwork for stability would be doing distributions over time. So rather than giving a 18-year-old a large sum of money, it might be better to have that stability and that installment of responsibility by giving maybe just a little bit to at 18,
I was perfectly
21.
mature.
Okay. So yeah, let's just give an 18-year-old millions of dollars.
Yeah, no, that's definitely a good one. I mean, because you can also do it at other ages. It doesn't have to be 18 or 21. It can be 25. It can be 30, 35. You can structure it that way.
It's definitely giving time for some maturity. Yeah. So
I have a quick question about with powers of attorney and if it's and medical powers of attorney and things like that, but specifically financial type powers of attorney. Are you seeing clients having issues with their children or other heirs approaching you as the financial planner for the parents and saying, oh, I think he actually wanted to do this, or I think she actually wanted to have this kind of plan put in place? Have you had to come back and say, do you have the power of attorney to make these kind of changes? And are you allowed to do that?
we have had situations like that, and we have told them that they need to go to a lawyer and bring back some type of documentation by a court to tell us that they have jurisdiction over whatever it may be. Yeah, any changes that they have. If they have conservatorship over the client, then we need to have that documented. We need to make sure that everything is buttoned up properly. We've had clients that have come to us and said that their parents have passed, and that person has just passed. Like
Right.
they're still waiting on someone to bring them to the mortuary. Like, and we need some type of certificate of death. Like, so there's definitely been some unique situations, and we kind of lean on both the home office for support and kind of get some guidance as to what to do next, but we don't make any of those rash decisions.
Yeah. Well, one last question, Kate. What should someone look for when building their advisory team?
Definitely focus on people who are communicative. You want people that are trustworthy. You want people that are open and honest with you and that provide clarity rather than having a conversation and you have a lot of additional questions. So you want people that are willing to work with the rest of your team of advisors and professionals. They should be able to ask you questions, and you should be able to reach out to the rest of their team so that there is no miscommunication. You're not playing telephone tag.
All right. Well, Kate, I want to thank you for joining us today. If somebody wanted to get a hold of you, what's the best way to do so?
You can give me a call at 757-417-1723, or you can email me at Kate Philleo at RaymondJames.com.
All right. Well, I want to thank you for joining us for this episode of I Now Pronounce You Divorced by Melone Hatley PC. We hope today's conversation helped bring more clarity and give you practical takeaways you can use during what may be one of the most important transitions of your life. Every family situation is different, and having the right guidance can make all the difference. To learn more about Melone Hatley or to speak with a member of our team, you can visit MaloneHatley.com. Be sure to subscribe to I Now Pronounce You Divorced wherever you listen to podcasts, and join us next time for more conversations designed to help protect your family, your finances, and your future.